This content is brought to you by Uphold, which makes crypto investing easy. I've been a user of Uphold since 2017. They're one of my go-to exchanges. You can buy, sell, and trade cryptocurrencies on Uphold. You can also trade precious metals and equities. They have 10 plus million users, 250 plus cryptocurrencies, and they're available in 150 countries. As with all exchanges, you can buy and sell on them, but I highly recommend you custody your own crypto, not your keys, not your coins. If you'd like to learn more about Uphold, please visit the link in the description. Welcome back to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is attorney Fred Rispoli, who's the founder of HODL Law. Fred, it is great to have you back on.
Oh, thanks for convincing me to do this. I appreciate it.
Yeah, Fred, I absolutely want to get your thoughts on the ruling that we got from Judge Torres yesterday. Can you summarize what that was about and what were the main takeaways?
Sure. The brief summary was just the order on the various parties and third parties' motions to seal various references in the motions for summary judgment, the Rule 56-1 statement, which is kind of like a companion pleading of all the facts, and then the exhibits themselves. And so the SEC wanted to seal expert witness information. They wanted to seal the Hinman documents. Ripple wanted to seal various financial information. Third parties, the most interesting one was investment banker A, wanted to say nobody gets to find out who I was because I was working with the SEC. And then Rosalind Layton, the attorney at Forbes, wanted to get the Hinman emails as a journalist and see what those were. So that was what was happening in a nutshell. We still had the Daubert motions pending when these motions were filed. Still had the summary judgment pending, obviously, when these motions were filed. And so now that's really the only thing left to go is what are these summary judgment rulings? And I think, again, when the Daubert or expert witness rulings came out, me and a lot of other lawyers said, man, we got to be really close because you can't make a ruling like that without having some idea of where you're going on summary judgment. I mean, you can, but it's a little, it doesn't necessarily go chronologically with how you might do something like that. And so now that the sealing motion came out, I mean, now we're really, really close. Like, it was any day before, but now it's very much so any day right now. And so that's what everything is, or the state of affairs. What the main takeaway from the ruling with the motion to seal, in my opinion, is basically that I think the summary judgment ruling is written. Is it 100% written? Is it 98, 99% written? That I don't know, but I mean, it's assuredly almost ready to go, if not ready to go right now, especially some of the things that she wrote in there. Not too much was really surprising to me other than the Hinman emails. Obviously, that's the most explosive thing that everybody cares about. And, I wasn't, I hope she was going to order them to be released. It wasn't going to be shocking to me if she did or didn't, because there were kind of reasons to go both ways. And what I think the big takeaway with the Hinman emails being released is if the court was going to grant the summary judgment motion completely for Ripple, she could have done that and said, we don't have to get rid of these emails or publish these emails, and kind of that was a way to get out of it. Not that I think that's kind of how Judge Torres operates, but that was one possibility, which, I still, there's still a chance for an outright Ripple win, but I'm still putting that at like a 10%. She also could have not released the emails because she was going to give the win to the SEC. And, I think that's a very unrealistic probability of them completely winning. I'd say that's less than 1%. And so I think ultimately, and what was really interesting was if you read the order, she wrote, I'm not even going to say, because real quickly with these Hinman emails, you got to remember the Judge Netburn, the magistrate judge, when she ordered them to be produced, she actually said they didn't have anything to do with the case in terms of a lot of relevancy issues. Only for impeachment purposes is what they might be used for,
Mm.
attacking the credibility of the SEC. And so the Judge Torres, in her ruling yesterday, said, I'm not even going to tell you if I'm going to use these or not in the motion for summary judgment, but what I'm going to say is these documents, and she cited another case, have a tendency to influence the court's ruling. So I'm going to order them released. And that was interesting because I kind of was trying to read between the lines, and I was getting the feeling that Judge Torres is probably not happy with the SEC's conduct in this litigation.
Sure.
These just some of these ridiculous arguments, the foot dragging. She knows what's happening on a broader picture of everybody's now jumping in to sue the SEC, complaining about these enforcement actions. So she knows all that. I
Mm.
don't think she's happy with the SEC's conduct. I think she's delicately and politely been now giving that off in the Daubert ruling and in this ruling. So I think this is all good news for Ripple. There are a couple of other things, but I didn't know if you wanted me to elaborate on anything with those emails.
Yeah, for the emails, we've seen historically there have been redacted versions put out there of different documents. Will this be redacted, or is it going to be the full shebang, so to speak?
So I don't quite know, because what you have to remember is when these emails were ordered to be produced, the SEC and the whole Judge Netburn saga, the SEC said, we still get to redact certain things. Judge Netburn allowed it. So it's not like these emails were always unredacted when they were given to Ripple. So there are some redactions in certain places.
Mm.
The second thing, and this doesn't have anything to do with the actual litigation, but when I sue big corporations, I love getting emails because they always say terrible things. Because people always, I've said this on your show last time, I said this to everybody, people just love putting stupid things in emails, myself included. And I'm a lawyer that always says before I send an email, well, imagine if a judge is reading this. So it's still, and I still do it. So the other thing, though, is we're relying on the SEC that they, in good faith, actually went through all the emails and put them all on the privilege log, which I don't have a high degree of faith in. Whenever I fight for emails, I always ask the court, and this is a lower probability, but I always ask the court, I want to bring my own IT guy to the defendant's location and do my own search, with them looking over my shoulder because I don't trust them.
Mm.
We never got into that here, and the judge never would have allowed it, but that's kind of an aside. Don't never trust this is the whole universe of emails.
Sure.
And then lastly, on the emails, I don't know if Ripple gets to produce everything they have, or if it's just limited to what was in the motion for summary judgment, what was in that Rule 56-1 statement, and the exhibits themselves. Because maybe they didn't put, the order kind of indicates that it only governs things in those documents. So maybe, they held back on a couple of emails, and the SEC might be saying you don't get to produce those. And so I don't know the answer on that one, but clearly it's at least at minimum summary judgment motion reference, Rule 56-1 reference, and the exhibits, those references.
Well, the folks at Ripple seem to think there's some a little bit of dirty secrets in those emails because of the language from Brad Garlinghouse and Stuart Alderati that the SEC is going to have some egg on their face once these emails and information is released. So I'm really curious to see what's in those emails. Do you have a approximate date? I think I saw James K. Filan highlight something about June 6th. Is that a date we can expect to see those documents?
I don't know what you're referring to. I haven't been on Twitter this morning actually, but the what usually happens, so there's some confusion about a motion to object. There's a rule for that, but that was for magistrate orders. We're past that part. I saw some other stuff last night about 10 days to file a motion for reconsideration of Judge Torres's order.
Mhm.
And I saw some reference that that was 10 days. I mean, so I think they could do that. Usually you always have an ability to object to something. It's whether you object before the other party can rightly start carrying through with the order. And then, Judge Torres didn't put anything specific about that in her order as when they had to come out. So I think if I were the SEC, I'd be trying to file something as fast as I can if I really wanted to object. But I mean, at this point, I mean, even the SEC's got to have some type of self-awareness that that's not going to go anywhere and it's going to hurt more than help their cause and just be seen as, whiny and annoying. So I don't think there's going to be any objection, but one thing I've learned is you can never put past the SEC to make a terrible decision.
For sure. So, like you said, they don't want these emails out there. But if they try to do any type of appeal now, it's just going to look lame. But, as far as the final conclusion of this, you mentioned you're foreseeing a Ripple victory. Do you think they will have to pay a penalty for things that took place maybe in 2015, but XRP today and future sales, secondary market sales are not securities? Is that the outcome that you're looking at?
Pretty much. So to get a little more specific, in the other portion of this document, the court largely granted Ripple what they wanted to get rid of or to keep redacted certain financial information, business relationships, specific contract provisions and whatnot. And based on what the SEC was trying to get unredacted, again, I think they ended up hurting themselves more than helping themselves because the things they wanted, they actually fought to keep unredacted,
Hmm.
came across as vindictive. Like we're trying to do our hardest to get all these, business trade secrets and business relationships out in the open. The court shut down all that, largely. And again, I think that's just going to her overall view of the SEC really not being a good faith actor. I know there's somebody on Twitter who always likes to post how it reminds the SEC that the SEC is not faithfully staying allegiant to the law. I see that a lot from a very popular person. I can't put my name on it right now, but and so I think she's got that mindset in her. But so some of the things that might be a little concerning for Ripple, maybe I've thought about it even a little more from last night, and you can go a favorable way too. Is she said there's certain things that Ripple can't unredact, and they can't keep redacted because it's very important to the Howey analysis. And so that was certain financial info like Ripple's revenue as a percentage related to their XRP sales, the listing fees that they paid to exchanges, and the targeted programmatic sales to investors. And so, I think why the court needs that, obviously, is she's going to address it in the Howey analysis that she's doing. And so does that mean that she needs that to say, yes, at least these three things do indicate there was some type of securities transaction? Or is she going to say, and that's the bad take, that's where I leaned initially, or bad for Ripple. And then, but there's also the other side of it, which is she can say, hey, these three things would be the closest that Ripple ever got to meeting these factors. And no, even this isn't enough to make it, a security sale. So, and again, those kind of very specific statements mean she's very close to wrapping this thing up. But I think ultimately what's going to happen is I think the court's going to say, these either one or two things on these early sales, because the closer in time you are to creating a blockchain, the more likely it is it hits all the security factors. Sure. And that's just, people always have to remember that there are a lot of things about cryptos that are very much like securities. The problem why everybody fights security designation because there's an equal number of things that just aren't.
Right.
It is not something that can be fit into that box, no matter how much the SEC wants. It's a whole new novel type of asset. So I think the court is going to do something still like either, hey, these programmatic sales, these early sales, this is when it met all the attributes. It was an unregistered securities exchange. But after this point, let's just pick the ODL date when they started doing that more.
Sure.
After this point, it doesn't meet the factors. A slight variation of that is, hey, in the beginning, it's very close that it could have met all of these factors, but we really need a jury to decide. So the jury's going to decide on this issue. And, after 2018, they're not securities. Or even after 2018, anything Ripple sells could be a security, and we'll let the jury decide. So I think there's going to be some issues that she's going to say the jury has to decide, or unless, the cleanest thing is coming up with some way where she does this amount from pre 2018, or I mean, I'm just picking a date,
Okay.
our security sales. That's done. Everything after that's not, we don't need a jury, figured out from there. I do think some things are going to have to go to the jury trial, but what I think is going to be the most important, and originally I thought it might be a little bit better for XRP secondary sales. Now I'm going to say it's slightly less. I've said this before, is that there'll be a holding. XRP itself is not a security. Secondary sales, I originally thought she was going to say aren't securities transactions. Now I just think she's going to say secondary sales aren't before me. The SEC goes back and forth as to whether they're alleging that, and they do, and that's just bad litigating, because they go one way, they go back, whatever. But the court will say, I think these secondary sales, with all these amici that have come in, have shown that the SEC has not met its burden to say any XRP transaction anywhere is a security. So I'm only going to focus on Ripple.
Mm.
Anything that ever happens with secondary sales, that's got to be a different case, which isn't extreme clarity, but it's enough practical clarity that, exchangers, if I were their lawyers advising them, I'd say, you can relist XRP, because now it's going to be all up to the SEC suing everybody individually, you, me, for using XRP on the secondary sales. And they're just not going to do that, and they can't do it. And so that's why I think that's going to be at least good enough. And that's still where I am. So in to rephrase everything I just said in 30 seconds, I think 10% chance Ripple gets the outright win. I think my 80% probability is these early sales, there's a question of fact, so it's going to go to a jury. But XRP itself is ruled not a security. Secondary sales are ruled not to be at issue in the court. And then at that point, the SEC will be like, we don't want to go through this whole trial process over something we don't even have an issue for going forward, post 2018 or whatever. So we'll tell Ripple, pay us this, and we're good to go. And then, hopefully that'll be that.
So is it fair to say that by June, we will be at that point where XRP has its clarity? Do you think?
I think so. I think that, so it's under the rules, the judge could wait. She doesn't want to be on that list, and she'd be on that list of late rulings by September. It doesn't matter if you're on the list, you can still hold off, ruling. So theoretically, she could easily go to the end of this year. I mean, not easily, but she could go to the end of the year if she wanted to, and just it doesn't seem rational or like her. So I don't think about that. I would say, in my best estimate, all the way she's steadily dropping all these things, I really think that we're getting a ruling by June, and I'm going on a nice cruise vacation on June 9th. And so I would love this to happen either the day before or while I'm on the cruise, so I can really celebrate hard. Not that I won't be having fun anyway, but
Right.
it would be nice. I mean, it's any day. It just is hard to imagine there's that much more delay left in this.
Mm. Boy, it can't come soon enough. I think the entire crypto industry is looking at this. Let's say that scenario plays out, right? And XRP gets the clarity. There are some who are saying that might be both good and bad for the industry because it would just mean XRP has the clarity while Gensler is attacking everything individually using shady tactics by suing exchanges, just throwing a bunch of coins in there and saying, all these are securities without litigating them individually. What do you think? And this is a hard question. What do you think the precedents will be? Will the industry be able to use some of the outcomes from this lawsuit to their advantage to fight back?
Well, it's not that hard of a question because you've already seen what's going to happen with the library case.
Mm.
Once the library summary judgment came out, the SEC said in its motion, everything is just like library here with Ripple, we win. And then Ripple's lawyers said, here's all the reasons why the library case wasn't like our case. So once this case comes out, if it's a win for the SEC or any good parts for the SEC, they'll tell the judges in their other cases, look, we're right on all these points. And then the other crypto companies that are getting sued will say where Ripple wins in any way, shape, or form. Look, we are just like Ripple in all these ways. XRP, we're like XRP. Our token is like XRP. This is why we should win. So it'll just be continual one-off battles in various spots of the country at this district court level ruling in the Ripple case. Now, perception can become reality. So if all of a sudden all the crypto exchanges, decided to relist XRP and said, we're relying on this, they could reasonably, legally, especially for their shareholders, say, we're going to rely on this court case and relist and evaluate it with other tokens. Well, now, the SEC's got a much bigger battle because the longer these exchanges list everything, the longer they don't attack them with enforcement suits, the harder it ultimately is to get them to win. So, you can, whatever the outcome is, people are going to pick the little morsels that they'd like and dislike, and the battles will still continue until there's congressional clarity.
So speaking of exchanges, Coinbase is suing the SEC after getting a Wells notice. There's been a bit of back and forth where the SEC is saying, hey, we're looking at a 10 to 20-year timeline for rulemaking and all that nonsense. What are your thoughts on how that is playing out so far?
I like that Coinbase finally did something. And so great, at the 11th hour, they filed some amicus briefs in other places. So they're being drug into this fight, despite their best efforts to, not be a leader in the space. But this suit against the SEC, you just have to remember the whole point of the suit. It's just because that they're seeking the SEC to force a response to a almost year-old request to make a rule.
Mm-hmm.
And so, that is kind of indicating that they cede some authority to the SEC on, having the ability to regulate crypto, which, people have to remember that fact. So that's not good in of itself, just to say, listen, we agree that you get to make the rules and now we want you to make them. So the court can either say, and after reading the SEC's brief, there is case law that says they don't have to make rules on any given timeline. And we can talk about the case I've got against the SEC with Ethereum. They said the same thing. I sued a little different way, but their response was like, we can't be forced to say anything. We can just sue you whenever we want. What I think is going to happen with that case, with the SEC Coinbase case, is I hope, the court could easily say, no, SEC doesn't have to make a rule. What I hope the court's going to say is, no, you do, especially considering you're suing everybody. That's the big difference, is they're suing so many people without making rules. But, ultimately, what does that mean? The SEC could all of a sudden say, they could spend a week thinking of a rule and say, no, or actually they don't even need to think of a rule. They could just say, no, we deny your petition to make a rule. And then so the whole process starts over. So I don't think it's got Could be wrong, but I don't think it's got a lasting impact. It's more of a poking the SEC in the eye, which is, enjoyable to watch. But I think considering what's at stake and the procedural posture of that lawsuit, I don't think it ultimately means much in the end, but it's better than nothing.
Mm. Final item here on Coinbase, because you were also suing Coinbase regarding the Flare token airdrop. Now they finally upheld their promise to distribute the Flare tokens that has started, but they have not said anything about the Songbird tokens. What's the status on all of that?
So this summer we've got some a big motion battle that'll be happening in our Coinbase class action. They did again. I really want to give a shout out to the plaintiffs in that case that were willing to put their names on this and do it. Peter Heffervich, Dr. Heffervich, and Dallas Woody on that one. Two awesome people who really, are very strong, dedicated members in the XRP community to be willing to do this. And when this, it's funny because Coinbase said, oh, we're going to think about Flare in the first half of this year. But when, we started having conversations with legal counsel about getting things ready in the briefing, all of a sudden you saw Coinbase tweet, we're going to think about Flare. And then like 3 days later, like, we thought about it, we listed it. Because that was a real easy way for them to get out of accruing continual multi-million-dollar damages. So,
Mhm.
I do think the plaintiffs had a hand in getting that release, not as early as we wanted, but I think they had a hand at forcing Coinbase to release that earlier. So the Flare is not the biggest issue in the lawsuit. The damages from the failure with Flare from January to April would be, but the biggest issue is Songbird. And so we're still going to be, pursuing that aspect of it. But what we're going to be fighting over in the summer is a motion to compel arbitration. If you look, I encourage everybody, anytime you do this, not on a crypto exchange, but whenever you see a term of service, you scroll down at the bottom. It's hard because it's constantly hidden in the documents, but there's like, you're waiving your right to a jury trial. You agree to arbitration. And that's like a private court in the US system where you pay money to someone to look at your case and evaluate it. And it's usually fine for two huge companies, that don't want to go through the court process, but it's a sham when it's against the consumer because, the people who run the arbitration are selected by the huge corporation that picks up all the fees. So they've got a very high incentive to rule in favor of that company all the time.
Mhm.
And the side point also is if you ever want to, one of the great things to do if you see these terms of service is just send an email to their customer service after you sign that, saying something like, there's no way for me to make any modifications to this agreement to click through, you force me to, but I just want to say I'm striking out the arbitration provision. I won't follow that. And, here's my notice of doing so. That doesn't necessarily mean that's going to work legally, but it's a great piece of evidence.
Sure.
But we're fighting. Coinbase is going to try and push everybody into arbitration for the Songbird issue. They're going to say, hey, you got to arbitrate and you've waived your right to do a class action. It makes everything not impossible, but a lot more difficult because, for me, as an attorney, I make an attorney's fee off of what I can help recover for the clients. And it's a lot simpler to do that in a class action where you've got, there's definitely a lot of people that have reached out to me that had, hundreds of thousands of dollars of Songbird or Flare they didn't get. But it's hard for me as an attorney or any attorney to help somebody on an individual basis that maybe only has, $200-300 worth of Songbird that was stolen.
Mm.
Because if you just looked at me helping them litigate that case, I'd easily spend, 30, 40, $50,000 to go through that case.
Sure.
And it's just obviously not workable or possible when at the end of that day, I'd recover, $200 for somebody,
Right.
of which, some of that would be a contingency fee for me. So that's why these companies like forcing everybody into arbitration and getting rid of class actions, so they can kind of keep the stolen money that they have.
Mm. Fred, good stuff. Thank you for the information, and I hope we get the summary judgment news before your cruise, and you can party hard, my friend.
Yeah, I hope so too. It'll be epic. I just have to make sure it's not, too much of a party so I can survive, come back, and spend my XRP.
For sure. Awesome. Thank you, Fred.